Agreement for rebuttal. Honors, in this case, it's a criminal case, and we're asking for a remand for a new trial based on the trial court's admission of some disputed text messages that were admitted into evidence as direct evidence of my client's guilt at the trial over defense counsel's objection. Now, I think it's important for us to talk about these text messages were not messages that were sent from my client's phone. They were sent from another phone. That were other phones that were involved in this criminal act, which was prosecuted as involving 4 criminal actors. So the state had a theory of guilt that involved 4 individuals committing a crime, conspiring to commit a crime, although they weren't charged with conspiracy. And the state's theory alleged that these 4 people committed this crime, and 2 of the phones that exchanged the text messages of the two telephones at issue, neither one belonged to my client, Mr. Faust. Now, at trial, and I went through this in the brief in some detail, at trial what appears to have happened, and what I suggest in my briefing, is that it appears that the parties were under the impression, including the trial court, that the second female witness was going to come into court and testify. And when that never materialized at trial, the second female witness, who the state says is a speaker in the vast majority of the text messages at issue, that her testimony never materialized. She didn't appear at trial to testify. And then the legal reasoning that was used to introduce her alleged statements into my client's criminal trial was threefold. The first hearsay exception that was relied upon by the state and the trial court below was the business records exception. And I've argued before the court, and it's based on this court's prior holdings as it relates to hospital records and other kind of business records, that simply because these statements of a non-business actor were captured by a business.
Well, before you get to the exceptions, was this hearsay at all?
Yes,
I mean,
sir.
that's the first question you have to get past, I think. But before you get to the exceptions, we don't have any need to talk about exceptions if it's not hearsay.
That's correct.
And tell me if I'm wrong, but it seems to me that the second phone was a phone that was not belonged to your client, but there was some evidence indicating it was in his possession.
That's correct, Judge.
And the other phone was in the possession of someone who was inside the house.
That's correct. Actually, both of the people that were inside.
All right, then tell me, why were not these text messages admissible to show that there were communications going on between the people inside the house and the defendant who was outside the house?
If that was...
in other words, they weren't offered to prove, for example, and this is the state's argument, and I'm asking you to knock it down for me if you can. The state argues in its brief that it was not germane whether this guy was going into the bedroom now or whether he had a gun now or this or that. The point of the whole thing was these 3 were inside the house communicating to the guy outside the house to let him know when it was or was not safe to come in and do what he was going to do. Now, the content of these emails, if the state is correct, are not offered. It's not offered to prove that what was said in them is true, only that the communications were in fact happening. So why is that hearsay?
Judge, and so the state is arguing in its brief that they weren't introduced for the matter. It wasn't to prove the truth of the matter asserted. Right. And I respond to that in 2 ways. First of all, I asked the court to look at the trial record and look at how these messages were utilized by the state at the trial. And if you look at the trial record, you'll see the state not making that argument, Judge, in closing argument, but instead pointing to the jurors to the content of the text messages. The content itself of the message is an indication that my client set up the victim. The content is an indication that a robbery was committed. The content is an indication that an attempted robbery was committed. The content of the message as an explanation for why no DNA evidence was found at the crime scene. So the first response I'd have to that argument is if you look at the trial record belies that kind of an argument that, well, we're just introducing this to show that the statement was made. My second response to that argument would be if you look at the state's brief in this case at the appellate level, the state argues that these messages weren't introduced to further actual content, instead to establish that the appellant was outside the residence obtaining information from the women inside to determine the location of the victim. Well, those are the messages. And so I'd say that both at the trial level and at the appellate level here, that argument that these statements weren't introduced for the truth of the matters that were asserted, that argument's undermined by what the court has before it in this case. And I also remind the court obviously when a state wants to put in a statement that's hearsay, otherwise hearsay, and say, well, the statement is not being introduced for the truth of what's asserted, the case that deals with that, with text messages, first of all, it has to be a materially disputed issue. And then secondly, the case law that deals with that in terms of text messages is like in a possession case where somebody's being prosecuted for the possession of the cell phone. And the statement, was a text message was sent in by somebody with the same last name as the defendant. And the text says, I love you. Well, obviously not, that text isn't being introduced to show that, his mother, the defendant's mother loves him. That text is being introduced to show that, hey, this defendant is saying this is not his cell phone. Well, look, there's a message here, from somebody with the same last name that says, I love you. So I'd say this is a different case, where what we have here in Mr. Faust's trial was a case where the statement was introduced that were directly inculpatory as the offense, or argued to be such, and so that argument that it wasn't introduced for the truth is
What was it that was harmful to your client in the emails, if you could tell me? And I don't mean that to be a silly question, but if you could translate those, not the emails, the text messages,
Right.
You know what I'm going to say.
Yes, sir.
Because, it's partly text message lingo, which escapes me, and partly extremely poor grammar. And so I don't really know what in the world they're talking about. It sounds like gibberish to me. What was it? Tell me in one standard English sentence, if you can, what it was in there that really hurt your client.
Well, the argument from the state was that these were messages that were, received by, and then the other messages, the outgoing messages, were typed by my client, and the content of those text messages, and I might not be a great interpreter in this case, they were argued that this was the communication where, okay, the victim is in X room, there is a firearm in the building, have you unlocked the door? No, the door is still locked. This might take some time. Okay, let me know when the door is unlocked. I'm coming in. Okay, wait a minute, and then it's unlocked. So that was.
Well, what is it about that that's harmful to you? It seems to me the harmful thing is that this discussion was ongoing, which was giving minute-by-minute, play-by-play information to your client who was outside ready to come in. That was the point, not that, I'm going in the room now, whatever those messages mean. I mean, the content of the messages don't seem to be terribly incriminating. If they do, tell me.
Well, he says, I'm coming in. I mean, first of all, I'm not conceding that my client was the originator of the incoming text messages.
I understand.
One thing that's important to remember about these four, and I call them the foursome in my brief, is that the foursome is comprised of two young couples, romantic couples, and then one of the males is a brother or a half-brother. It's one of the females. So there's a whole bunch of relationships going on here with the foursome. But the problematic, for the defense, portions of these text messages are, if you take that the record establishes that my client was the one typing or originating the incoming text message, that, okay, we're coming in, get him in the back room. I mean, these were argued, and they were argued as such, statements of basically, prep statements for a robbery and or basically an assassination, to be honest with you. I mean, they're acutely damaging to the defense case in this matter, and they were so below, and they were relied upon extensively for their content at the trial, as reflected in the record by the state. They were placed on a board. There were different colors assigned to the ingoing and the outgoing text messages. The state inquired of the jurors as early as jury selection. Who among you is familiar with text messages? Who among you, is familiar with that process? Do you have any relatives who utilize that technology? They were arguing an opening statement. They were arguing a closing statement. So this wasn't just some, ancillary indication of guilt. When the state's second witness, the second female witness, Ms. Pate, did not testify, these text messages specifically became very important to the state's prosecution of my client, and critical if you look at the records of the arguments in obtaining his conviction. As to the business records, I think that's pretty well established by the case law in this court. There's a Thomas case. There's a Neely case. One thing I wanted to talk about was this notion that the statements may constitute co-conspirator statements. One of the things that the case law, and to some extent the rule require in such a circumstance, is proof that both the speaker and the defendant were involved in this conspiracy, in a criminal conspiracy. Well, if you look at the record in this case, neither the speaker, if you take the other female as being the speaker, which is what the state argued below, that the other female had created or authored these text messages, she never testified. I mean, she didn't get up there, and this is apart and separate from a case where somebody gets up there and says, oh, me and Mr. Defendant, we plotted this out, and that's the guy right over there, and these are the text messages he sent me. That never happened in this case, because the state is arguing that this other female defendant authored these text messages. Well, she never testified. My client never testified. My client gave no pretrial statements. So
what about the spontaneous statement exception, assuming this is hearsay? I thought the trial judge made an interesting observation that this would not be excited utterance, but that it very well may possibly be spontaneous statement, which reflects kind of an uncommon, in my opinion, understanding between the difference between those two things. You wouldn't have to be excited to make a spontaneous statement.
You wouldn't. I agree with that.
So why this was going on as the crime was unfolding? Why wouldn't it be a spontaneous statement?
Because there was no foundation laid for spontaneous statements as to the contemporaneous nature of the event and the statement.
Wasn't there one of the co-conspirators who testified to the fact that the one phone was in the house and she saw the other girl texting, and then the next thing she knew, somebody burst in the door with a gun, she screamed. Was there not some testimony that the texting was going on during the event?
I would disagree with that based on the record in this case. And you have to remember the one female who did testify was a very difficult witness. And I encourage Your Honors that if you take a look at her testimony on direct, she was a difficult witness to the extent the state asked to treat her as hostile at one point. And she did not testify that, well, within a few minutes of that text, X happened. That was simply not established. And so
all these messages are time-stamped.
They are, Your Honor, and they're time-stamped. And the period of messages, the span of the 12 messages, is an hour and 10 minutes. And what we have is case law in the state here from this court that said specifically in the past, in 2004, that 20 minutes is too long. 20 minutes, it's not spontaneous anymore. There's a Florida Supreme Court case called Hutchinson from 2004 that says 10 minutes is too long. And so my argument is that the appropriate relationship...
Well, you're saying the span of time that they were texting back and forth was an hour and 10 minutes.
That's correct.
You're not saying an hour and 10 minutes elapsed between the observation and the text regarding it.
That's correct, Judge. But and I would argue it, I'd probably or maybe argue it differently if there was record indication that I saw X and texted Y, and that simply was never established. Yeah, I'll reserve the rest of my time for
Thank you.
Thanks.
May it please the Court, Giselle Island on behalf of the State of Florida. I would first ask the Court's indulgence and ask the Court to take judicial notice of this Court's decision in Stephen Ferris v. State, 1D06, 5627. It's a case in which this Court PCA'd the conviction, but it dealt with the admissibility of text messaging. This is not a case of first impression before this Court. As Judge Padavano pointed out, the State asserts that...
Yeah, but it was a PCA, so how are we to determine what the ruling of that panel was?
If the Court takes judicial notice of the file itself, it can look at the contents of the file and deal with that. So it's not...
Okay.
It's a perfectly acceptable way, Your Honor. In this case, the State is asserting that it was not a hearsay communication. First of all, the numbers and the signatures are not hearsay. This has been decided in this State that that is not hearsay. So the only question is left whether or not it was hearsay as to the content. The fact that the phones were in the possession of different people was totally irrelevant because Xander Ford testified that the phone that was inside the house belonged to Amos Jenkins, her boyfriend, and LaToya Pate's brother, and the other phone also was one of that party's phones. And below a trial, the defendant never complained that it was impossible to say who had what phone, so that really wasn't an issue below. As to the actual content, they were not admissible because the State was basically offering them to show what the effect of those messages was on the defendant and what he did in response to them. So it really wasn't the content of the messages at all. And the State submits, as the Court pointed out, if you look at the content of these messages, they're basically neutral. There's absolutely nothing inculpatory in them at all. And let's face it, all evidence of guilt is going to be prejudicial. Questions which is what part of these messages are comprised of, are generally found not to be hearsay. And in Eugene versus State, the 4th District Court dealt with a case involving text messaging and held that in that case it was not offered for the truth of the matter asserted. The state also relied upon this as a business records exception. Basically, what the court has to focus on is a business record not because the company is verifying the accuracy of the actual content of the message itself. All they're doing is saying that it's a fact that this communication took place at this time within these cell towers between this phone and that phone. The question of whether the content of the messages itself is truthful or untruthful is not a question of admissibility. It's a question of weight that has to go to the jury. So as long as we can say that these were business records exceptions, then it's up to the jury to decide whether or not it wants to believe the content of those messages. Below, with regard to spontaneous statement present sense impression, I'd like to ask the court to look very carefully at what was discussed. Because while defense counsel said he wasn't not going to object, he basically had absolutely no basis to support a contention that it was not a spontaneous statement, which the state would conclude as something of a waiver on his part. Here it's clear that regardless of the time involved here, this was an ongoing event, and these messages are passing forth between the women who were inside the house and the appellant who was outside the house waiting for the opportunity to come in. Ford did in fact testify as to some of the contents of these statements, and I'd ask the court to carefully look at the record on that point because she admitted that she personally made some of them and that she saw statements coming in and other statements that were going out. Additionally, the demonstrative aid itself would show that these were spontaneous sentences because the time frames are there. It showed the, I'm not quite sure how to put it, the triangulation towers for the agency to show where they were located at that time. It shows the phone that they were sent from, the phone it went to, and how long it was. The other side showed the actual messages. So it was very clear that this was part of an ongoing act. And basically, I think it's pretty clear that anybody who's inside a house while a home invasion robbery is about to take place is going to be pretty excited and is not going to have that moment pause of time to fabricate some kind of a story. As to the co-conspirator statements, again, all the state has to do is prove by a preponderance of the evidence with independent proof that there was such a conspiracy. Here we have Ford, who again gets on the stand and says, I sent some of these messages, I received some of these messages, and you also have the fact that these are exchanged during a very limited period of time. The independent proof here is that Christina Smith is actually the key to tie all of the parties in this case together. She happens to be a friend of the victim, and she also happens to be a friend of LaToya Pate. Through Ms. Smith, Pate and Ford end up going over to the victim's house. They see that this man is a very successful businessman. He lives in an expensive home, drives a Mercedes and an Acura, and they basically, through Christina Ford, get the opportunity to go into the home and kind of scope it out. It's very curious that Christina Ford, who was invited over to hang out with Pate and Jenkins the day of the robbery, she goes over there and appellant shows up. He says, put your shoes on, let's go. And she's like, huh? And everyone goes to get in the car with the appellant. And Christina Smith wants to go with them, but she's told by LaToya Pate she can't go. And the reason for that is she's the victim's friend. So she's not going to stand by and let this happen. And when the women get into the car, they get into the back seat with the two men in front. They get to the victim's home. The girls get out of the car and are told to go inside. Appellant and Jenkins drive off, come back after they're in the house, and then appellant comes in with the AK-47. Also of note is the fact that appellant told the girls after the fact that when he had come in the door with the AK-47, they obviously were afraid. They screamed and they hit the floor. And when they got back into the car, he basically said, what did you scream for? You weren't supposed to do that. We were there to rob him. So the state submits that there was plenty of evidence independent to support a co-conspirator. So for a variety of reasons, the state submits that the court correctly admitted these text messages. As I stated earlier, the probative versus prejudicial value element of this is, I think, irrelevant because these text messages are harmful in the sense that they place him in the area, they place him going into the robbery, they help support the case. All evidence of guilt is going to, be harmful for him regardless of what it is. The state would also submit that even if this court said that the text messages should not have been admitted, that any error is harmless. Christina Smith places places the women in the home in the sense that they know what is there, they know what they want. Ford testifies as to the content of some of the messages she sent and received. She's the one that says, I saw appellant through the side lights of the front door wearing a white t-shirt, and a second later the door bursts open and he comes in. She's the one that places appellant standing at the bedroom door into which the victim fled, putting the AK-47 up against the door and firing 3 times, killing the victim. And finally, the cell phone numbers and signatures are independently admissible. For all of these reasons, the state respectfully asks this court to affirm. Thank you for your time.
Thank you, counsel.
May it please the court, as to the issue of preservation, I'd ask the court to take notice of the trial court, Judge Walker's statements made on the record in this case, where he said specifically and overtly, his exact words were, let me make this plain, that your hearsay objections are preserved. And so the trial court was under no belief or no feeling that defense counsel hadn't thoroughly preserved his objection to the admission of these text messages. These text messages, the admission of these messages, and he says that he's troubled. The trial court says, I'm troubled by the case law on this issue. He was careful about admitting them, and he specifically went out of his way to tell defense counsel and all the parties that the objections, the hearsay objections to the text messages were preserved. As to business records, simply because a statement is captured by a business, a statement of a non-business actor, doesn't allow that statement to come into evidence just because it's housed in one business's record or a business's record. I mean, otherwise, the hearsay, the rule against hearsay would be seriously undermined. I mean, if you think about all the businesses they operate and all the statements that their records may or may not capture, I think it's important to look at the case law where it's over and over again it's been held that the statement must be of a business actor, somebody under a business duty to record and make that statement. And that goes along with the justifications of allowing business records in. Otherwise, any statement in a voicemail or any other type of communication that's housed or sent over a server or another kind of electronic service provider would automatically be admissible. It would be not hearsay because it's been captured just haphazardly by a business along the way at some point. For these reasons, we're asking the court to reverse. Thank you.
Thank you, counsel.